be seated.
Juror number 8. What number are you?
16.
Okay, well, we're going to have to ask you to vacate that seat. Can you please stand? Okay. What we're going to do is, sit in your original seats. We're going to draw by lots which 2 jurors are going to be seated in seat number 3 and seat number 8. Madam Clerk? And I've also given a media instruction not to live stream the jurors.
Juror number 18, seat number 3. Juror number 17, seat number 8.
Sorry guys, the ladies won. We're going to give you cushions. Very good. Can we get those cushions for them? Very good. Ready, Madam Clerk? I'm sorry. Okay, very good. You call again.
Case number 13-8320, the People versus Robert Bashara. Today is the day for a jury trial.
Appearances for the record.
Good morning, Your Honor. Lisa Lindsay on behalf of the state of Michigan.
Yeah, please swear, Your Honor, Robert Moran, Assistant Prosecutor.
Good morning, Patrick Muscat on behalf of the people.
Good morning, Mark Hindelang on behalf of the people.
Judge, good morning to you and your staff. Lillian Diallo on behalf of Robert Bashara, who's present to my left.
Good morning, Your Honor. Michael McCarthy, appearing on behalf of Robert Bashara.
Very good. Good morning. Okay, open your books. The 3rd page at the bottom. Now this is what I want you to do. Look to your left, look to your right. Make sure your neighbor has a 2.1. 2.1. 2.1. Look to your neighbor. Make sure everyone has it. 2.1. If you don't have something that I'm reading, alert me. Let's just wait for juror. We got it? 2.1. Does everyone have it? Raise your hands if you have it, please. All right, for the record, everyone has it. I'm going to read along, okay? And as I read, just turn the page. After I conclude the instructions, the people, because they bear the burden, will go first. They will each have 45 minutes to do opening statements. After each one does opening statements, I'm going to take a 10-minute recess, and then we'll let the other side do their opening, take a 10-minute recess, and then we will probably go for lunch. And after lunch, we will begin with our witnesses, okay? Very good. Ladies and gentlemen of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Here is your oath. Please stand.
You do solemnly swear or affirm that you will well and truly try and true deliverance make between the people of the state and the defendant of the bar, whom you shall have in charge according to the evidence and the laws of this state.
Please be seated. Now explain some of the legal principles you will need to know and the procedure we will follow in this trial. The trial follows this procedure. First, the prosecutor makes an opening statement where she gives her theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes hers, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents her evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has a right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all her evidence, the defendant's attorney may also offer the evidence but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like opening statements, these are not evidence. They're only meant to help you understand the evidence in a way each side sees a case. You must base your verdict only on the evidence. My responsibility as a judge in this trial is to make sure the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. When it's time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted in evidence, and anything else I tell you to consider as evidence. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witness. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was a witness able to see or hear clearly? How long was a witness watching or listening? Was anything else going on that might have distracted the witness? Does a witness seem to have a good memory? How does a witness look and act while testifying? Does a witness seem to be making an honest effort to tell the truth? Or does a witness seem to evade the questions or argue with the lawyers? Does a witness's age or maturity affect how you judge his or her testimony? Does a witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does a witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all the other evidence in the case? The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assumes or suggests that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinions about the evidence. If I ask questions, my only reason will be to ask about things that may not have been fully explored. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you're in the jury room, I may have to take care of matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss this case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it's time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. When the trial is over, you may, if you wish, discuss this case with anyone. This is very important. Even when you're out to lunch, you can't say, what'd you think about that witness? Oh, no comment, no discussion about any testifying witness, okay? There will come a time when 12 of you will be selected to do deliberation, so you can't discuss the testimony ahead of time, okay? If I call for a recess during the trial, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business, but you must not discuss this case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain as a juror you are not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. You must not talk to the defendant, lawyers, or witnesses about anything at all, even if it has nothing to do with this case. It is very important that you only get information about the case in court when you're acting as a jury and when the defendant, the lawyers, and I are all here. as the court had instructed you the other day through its legislative assistant, my administrative assistant, Ms. Rowe. You are not to watch television, read the media about anything that has anything to do with this case. That is a daily instruction. Do you hear? That's what you have to follow. You can only get your evidence in court because you are the judges of the facts. During the trial, do not read, listen to, or watch any news reports about the case. Did I say you can't watch the news? No. You can't watch the news about this particular case, all right? Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because the news reports do not have to meet these standards, they could give you incorrect or misleading information. They might unfairly favor one side, so to be fair to both sides, you must follow this instruction. Remember, for the reasons I explained to you earlier, you must not read, listen to, or watch any news reports about the case while you are serving on this jury. Turn the page. The restrictions I'm about to describe are meant to assure that the parties get a fair trial. In our judicial system, it is critical that jurors are not influenced by anything or anyone outside the courtroom. Now that many jurors have access to information through handheld devices and other technology, jurors may be tempted to use these devices to learn about some aspect of the case. But if a juror were to do this, it would harm the parties. The parties' attorneys would have no way of knowing that a juror has gotten outside information, and we have no chance to object if that information was false, untrustworthy, or irrelevant. Remember, no matter how careful and conscientious news reporters, family members, friends, and other people outside the courtroom may be, information about the case from television, radio, the internet, and social media will inevitably be incomplete and could be incorrect. Please bear these things in mind. As I read the following instructions, these restrictions apply from this moment until I discharge you from jury service. You must decide this case based solely on the evidence you see and hear in the courtroom. In this courtroom, you must not consider information that comes from anywhere else. This means that during the trial, you must not read, watch, or listen to news reports about the case, whether in newspaper, on television, on the radio, or on the internet. You must also not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, computer, cellular phones, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider any evidence, you must not consider as evidence any personal knowledge you have of the scene. Before your deliberations, you must not discuss this case with anyone, even your fellow jurors. After you begin deliberations, you should discuss this case with your fellow jurors. But you still must not discuss this case with anyone else until I discharge you from jury service. Until I discharge you from jury service, you must not share any information about the case by any means, including cellular phones or social media. Facebook, Twitter, Instagram, don't do that. If you discover that a juror has violated my instructions, report it to my bailiff. I don't believe that it is desirable or helpful for you to take notes during this trial. If you take notes, you might not be able to give your full attention to the evidence, so please do not take any notes while you're in the courtroom. Elements charged. I will now read the following counts that Mr. Bashara is being charged with. Count 1. Do you have that juror number 3?
Yeah.
Okay. The defendant is charged with the crime of conspiracy to commit murder first degree. Anyone who knowingly agrees with someone else to commit murder in the first degree is guilty of conspiracy. To prove the defendant's guilt, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant and someone else knowingly agreed to commit murder in the first degree. Second, that the defendant specifically intended to commit or help commit that crime. Third, that this agreement took place or continued during the period of time from October 2011 to January 29, 2012. The crime of first-degree murder has the following elements. The defendant is charged with the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Jane Bashara. That is, that Jane Bashara died as a result of strangulation. Second, that the defendant intended to kill Jane Bashara. Third, that this intent to kill was premeditated. That is thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. Fifth, that the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. Count 2, solicitation to murder. The defendant is charged with solicitation to commit murder. To prove the defendant's guilt, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant, through words or actions, offered, promised, or gave money, services, or anything of value to another person, Joseph Gens. Second, that the defendant intended that what he said or did would cause murder first degree premeditated to be committed. The crime of murder first degree premeditated is defined as: first, the defendant caused the death of Jane Bashara. That is, that Jane Bashara died as a result of strangulation. Second, that the defendant intended to kill Jane Bashara. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. Fifth, that the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. The prosecutor does not have to prove that the person the defendant solicited actually committed, attempted to commit, or intended to commit first-degree premeditated murder. Count 3. The defendant is charged with the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Jane Bashara. That is, that Jane Bashara died as a result of strangulation. Second, that the defendant intended to kill Jane Bashara. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of the case. The killing cannot be the result of a sudden impulse without thought or reflection. Fifth, that the killing was not justified, excused, or done under circumstances to reduce it to a lesser crime. Count 4, obstruction of justice. The defendant is charged with the crime of obstruction of justice. That Janice Lehman, Courtney Johns, Will Schatz, Teresa Griffin, Paul Monroe, Daryl Bradford, Rachel Gillette, and Robert Fick were all witnesses during the investigation of the homicide of Jane Bashara. To prove this charge, a prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed any one of these acts: attempting to arrange for a witness to be hidden from the courts out of state, and or instructing material witness to mislead, misinform, omit, effuse information about the investigation, and or threaten tenants and subordinates with negative consequences if they comply in candor with the investigation, and or engage agents to offer a bribe to a witness as consideration for false statements implicating innocent persons, and or initiating eviction proceedings against a tenant with the defendant, who the defendant believed was a witness against him, and or engage agents who harassed witnesses and hindered investigators, engage agents to hide evidence. Okay, let me read B again. Instructing material witnesses to mislead, misinform, omit, effuse information from investigators. I said investigations. Second, at the time the defendant committed the prohibited acts, the prohibited act or acts, the defendant had one of the following states of mind: the defendant intended to prevent the witness from speaking to the police about the homicide of Jane Bashara, and or the defendant intended to encourage the witness to be untruthful with the police. Attempting to discourage a witness from testifying or from being truthful with the police by words alone may be sufficient to constitute the crime of obstruction of justice. It does not matter whether the witness was actually discouraged from testifying. The crime of obstruction of justice is completed if an effort is made to discourage a witness speaking to the police about the homicide of Jane Bashara. The guilt or innocence of the person in this case in which the witness was to testify does not matter. The issue is whether the defendant, by committing one of the prohibited acts, intentionally attempted to discourage a witness from testifying to the police. Count 5. Witness intimidation. The prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant impeded, interfered with, prevented, or obstructed a witness's ability to attend, testify, and or provide information in or for a present or future hearing. Second, that the defendant had the knowledge or the reason to know that the person subjected to interference as defined above could not be a witness at an official proceeding. Third, that at the time the defendant committed or attempted to commit the prohibited acts defined above, he did so willfully. Count 6. Subordination of perjury. The defendant is charged with the crime of persuading another person to commit perjury. To prove this charge, a prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant tried to get another person, Robert Flick, to willfully swear falsely before Robert Moran, an assistant prosecutor for Wayne County, on a matter for which said oath is required, investigative subpoena. Second, that the defendant knew the statement was false at the time. Third, as a result, the other person made a false statement under oath. And fourth, that the oath was required by a law of the state of Michigan. Oath is required to wit an investigative subpoena. You can see that we have chosen a jury of 16. After you have heard all the evidence and my instructions, we will draw lots to decide which 4 of you will be dismissed in order to form a jury of 12. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial, and at the end of the trial I will give you detailed instructions about the law in this case. You should consider all my instructions as a connected series. Taken all together, they are the law you must follow. After all the evidence has been presented and lawyers have given their arguments, I will give you detailed instructions about the rules of law that apply to this case. Then you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it and must reflect the individual decision of each juror. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair and honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just a doubt that is reasonable after careful to consider examination of the facts and circumstances of this case. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury and decide the case. Have I complied with the jury reading of jury instructions?
Yes, Your Honor, I would note for the record that I believe on count. May we approach?
Yes. Let's go back to witness intimidation, count 5. I'm going to reread that instruction. The prosecutor must prove the following elements beyond a reasonable doubt. Everybody got it? Okay, great. First, that the defendant impeded, interfered with, prevented, or obstructed a witness's ability to attend, testify, and or provide information in or for a present or future hearing. Second, that the defendant had the knowledge or the reason to know that the person subjected to interference as defined above could be, I said could not, could be a witness at an official proceeding. Third, that at the time the defendant committed or attempted to commit the prohibited acts defined above, he did so willfully. Have I complied with the jury instructions now?
After the people, yes, thank you.
And on behalf of the defense, we are satisfied with it. Thank you.
Very good. Now, this is what I need you to do. Take your books and put them under your seat. Stand up. Let's take a stretch break.